free speech, let's bust a few myths surrounding this particular issue. One, is there anything called as absolute free speech in any jurisdiction? Frankly speaking, there are very few jurisdictions where free speech gets a free pass on every subject. And in fact, even the most liberal regimes, when it comes to free speech, observe certain restraints. Okay, because at the end of the day, if speech is targeted at a certain audience and it is not just limited to a specific issue and it is bound to affect another individual or let's say another community, most jurisdictions try and have some kind of fetters or at least some kind of reasonable restrictions. The question is, to what extent can a restriction be justified? What is the fundamental basis for, let's say, the state's intervention when it comes to individual exercise of free speech? Okay, and most people are aware that as far as India is concerned, until the first amendment to Article 19 of the Constitution, we did not have these restrictions that we see currently in the Constitution on free speech. These restrictions were introduced as part of the first amendment to the Constitution that was brought into effect by Jawaharlal Nehru in consultation with Dr. Ambedkar, with massive criticism from several members of the government then, including Sri Shama Prasad Mukherjee, who effectively said that the very same gags and fetters that the British man imposed on exercise of free speech on Indians appears to be, they appear to have re-entered the Constitution. And now the Indian government has kind of justified its position with respect to these restrictions and has effectively stepped into the shoes of the white man of the British colonizer, was the position that Sri Shama Prasad Mukherjee took at that point. Now, we recognize about 5 to 6 categories of restrictions on free speech as the law exists today after the First Amendment. Remember that while the First Amendment was challenged in the Supreme Court with respect to the land reform legislations that were brought about and with respect to the constitutional amendments made with respect to land reforms, those amendments that were brought into the Constitution with respect to restrictions on free speech were never challenged. They have not been challenged till date, meaning thereby that for all practical purposes, the Indian Republic has accepted, at least de facto, all restrictions that exist on free speech as they exist in the Constitution as on date. Okay, and we recognize defamation as one possible area. We also recognize, let's say, any disturbance to public order. Okay. Yes. Now, the IPC specifically recognizes certain provisions which have a bearing on religion and religious sentiments. Okay. So the two prominent provisions that are always discussed in the context of religion are section 153A and 295A. Okay. So one speaks of promoting enmity between two communities, which is 153A, and the other is specifically directed at hurting the religious sentiments of a particular community. Okay. So in most instances, both these provisions are combinedly invoked. They are invoked together because typically in 9 out of 10 instances, the person who makes a comment with respect to the religious figure of another community happens to be from a different community altogether. And therefore, law enforcement agencies deem it fit to invoke both 295A, which is hurting of religious sentiments of the other community, and promotion of enmity as well. These two provisions put together largely form part of what we know as blasphemy law in India. We do not have a specific statute as far as blasphemy law is concerned across the country. These are the two provisions that we typically invoke. Now, the interesting part is this particular provision, which we know as the blasphemy law, was subjected to a constitutional challenge in the Supreme Court. In fact, it was challenged, saying that a blasphemy law such as this has no business being in the statute book because, one, per se, it constitutes an unreasonable restriction on free speech. Two, it's a slippery slope where a mere theological disagreement or criticism of another point of view could translate to hurting somebody's sentiments. And each time you actually open your mouth to express a certain comment, you run the risk of offending someone or the other. Okay. And therefore, somebody's hurt sentiments or fragile sentiments cannot form the basis of my exercise of free speech. When I am making a perfectly legitimate point from either a theological perspective or even from a rational perspective, I don't need to be a believer in a particular religion to criticize another religion's point of view, has been India's civilizational approach. Because you see, there has been a healthy tradition in Indian civilization and Indian sampradayas, so to speak, of criticizing each other's approach to divinity and whatnot. Okay, so that hasn't stopped anyone from necessarily, let's say, living by what they believe in. It has never led to violent reactions. It has never led to a situation where somebody decides to gag somebody else at the expense of the sword or at the expense of life or losing their life or limb. That has never happened. That is a relatively recent phenomenon in India's civilizational journey. But in modern independent, or let's say modern India's history, this particular aspect has a history of at least 150 to, let's say, 175 years, I would say. Largely what has happened, I think this provision can be traced to a particular incident that took place in the northwest frontier province, which, of course, which continues to be part of Pakistan and as part of undivided India. So around that time, Swami Shraddhanand of Arya Samaj decided to undertake a certain activity of reconverting the Muslims of those parts of undivided India back to their original faith, which is Hinduism. And when this started, I think publications started from both sides or both communities where they started insulting each other's religions. So the community from which he was trying to attract people back into the Hindu fold decided to come out with a derogatory publication on Devi Sita. And in response, the Hindu community decided to come out with a publication on the religious figure or the head of that particular community. And that is what we know as the book, which is known as Rangila Rasool or whatever it is. Yes. Okay. And then this led to violent reactions from both ends. And I think a case was also instituted against the publisher of that particular book. And I think the publisher of that book was murdered in the campus of the court. He was assassinated as well. And this more or less forms the backdrop of the British government coming out with a legislation or let's say a law such as 295A for all practical purposes.
Did it exist before in Western?
So in the sense, before independent India, before the Republic, the law as we know today with respect to blasphemy had already taken shape. Okay. So what we have continued is a colonial instrument, so to speak, for all practical purposes in terms of that particular legislation. But that provision has been tested on the annals of Indian Constitution by a 5-judge bench, okay, by a constitution bench in Ramji Bhai judgment. And there the court has effectively said that when there is a clear intent to hurt somebody's sentiments and when there is a deliberate and malicious intent, so therefore it can't be inadvertent and it can't be something which lacks malice. So you require the twin requirements of deliberate as well as malicious intent to go after somebody's religious sentiments. And when you make such a statement, that is typically the situation where 295A is supposed to be invoked. Okay, but what the Supreme Court says and what the beat constable or what the station house officer of a police station does is very, very different. So 9 out of 10 instances, this particular provision is invoked at the drop of a hat. And the moment, let's say, a complaint of this nature is registered or an FIR is registered, you endanger the life of the person who has been named as the accused in that particular case, because then you brand him as a, let's say, a phobe of a particular religion, and then a bounty is put on its head and so on and so forth. Okay.